Hi, this is Jenny Microphone coming to you from Chicago as usual. And today I've got another fun one from Kim Blandino. I guess it's another pro se court fail. I was going to do this clip with Deborah Davis, but we were having a nice chat. I'll put a link to that video in the description below. That was for my 20K celebration. So I thought I would just go ahead and do the clip anyway, except by myself because it's good stuff. Let's do it.
You're entitled to testify if you want to testify.
Oh, no. Testify as an expert witness.
An expert in what?
I'm an expert in my own religious beliefs. After studying in comparative religious beliefs, and my religious beliefs are what motivated the conduct that the district attorney finds criminal, and which is no means is criminal. So I can testify as to Mr. Blandino, religious beliefs, how they've been developing and evolving over the years, and how that his main belief is not to do crimes.
And don't forget to hit like and subscribe, or the dogs get it.
State of Nevada versus Kim Blandino, KC 341767. Who is here on behalf of the state of Nevada?
Mike Dickerson on behalf of the state of Nevada, Your Honor. Bar number 13476.
Thank you. Mr. Blandino, would you like to make your appearance?
Okay, how's that?
Perfect. Go ahead. You can make your appearance.
Kim Blandino appearing pro se by Blue Jeans. They won't let me in the courthouse without a mask, and so I can't wear a mask, and that's why I'm appearing here. Necessity.
Thank you. Thank you. And Mr. Bateman, do you want to make your appearance?
Yes. Good afternoon, Your Honor. Ben Bateman, bar number 933, and I'm standby counsel for Mr. Blandino.
Okay. Thank you very much, and thank you very much.
Right off the bat, there is no way you can proceed forward. Tiara Jones has an unadjudicated motion to disqualify against her that was filed.
Mr. Blandino, I am going to proceed. And if you interrupt me, then I'm going to have the clerk mute your microphone. Okay? I am going to proceed. You can object. I understand you object to me proceeding over this. I got it, and the record will reflect that. So the first motion, the state's motion to remand the defendant or order additional conditions of release. Mr. Dickerson, do you want to be heard?
Yes, Your Honor. Thank you. So this motion was placed on calendar back in February of 2021 based upon the defendant sending the state
2020?
2020. The state.
As usual, shout out to our Nevada judges. I got this video. It's a portion of one of their videos, and they do a great job, and that's what I'm using here. But of course, Kim Blandino kicks it off strong with claiming to be an expert on his own religious beliefs, and then objecting when the judge tells him that he can't interrupt inappropriately.
It's been about a year and a half.
That's correct. The state sending the defendant sending the state a letter indicating extremely concerning things about him going to the named victim's home as well as municipal.
I object. It was a discrete distance.
Okay. You can speak after me.
Interrupt the district attorney. If you proceed on interrupting people when they're talking again, I will mute your microphone. Mr. Dickerson, you may proceed.
Thank you, Your Honor. The defendant sending this letter to us indicating he's going to visit the named victim's home as well as another judge's home, and pretty much indicating in there that, hey, guess what? Looks like I'm no longer on high-level electronic monitoring, so I can do what I want, and the condition of no contact does not apply. I would suggest that since it has been such a long time, without a doubt, the court should, at the very least, make sure that it is clear that the condition of having no contact with the named victim, and I would also submit, as well as any other sitting judge or pro tem judge in Clark County, since obviously that's the basis of what he's indicating here during the time of his release on this case. That would be at a minimum.
Okay, and so I know that the initial no contact order was as to Mr. Federico. Is that correct?
That's correct, Your Honor.
And then I thought there was another judge that, I guess, presided over a TPO hearing, and that judge was a temporary judge as well?
The Shannon Nordstrom is a judge that the defendant has become fixated on over the years, and that's who he was indicating within the letter, that he was going to also go to her house to conduct some sort of surveillance upon her residence.
Okay. All right. So the state is seeking to just make sure that he understands those conditions?
Yes, Your Honor.
Okay, Mr. Blandino, do you want to be heard?
Okay. Again, I got to renew my objection. I'm only speaking. You don't have the capacity to move forward, but since you're forcing me to move forward, and I got to defend myself against illegal acts, namely you sitting on here when there's an motion.
Listen, Mr. Blandino, I'm not gonna go through this every time you have an opportunity to talk. You filed about 4 motions to disqualify. Each and every one of them have been denied. I have jurisdiction, and we're going to proceed. So if you want to talk about this specific issue, you may.
Okay,
go ahead.
I'm going to have, because they're trying to do something illegal here, and they're lying again on the record. I said that I would maintain a discrete distance to view that home, which would be any discrete distance that would normally be in a temporary restraining order or a protective order. The thing is that it was subsequent to filing a suit, which I have now filed. The court can take judicial notice. I filed a federal suit against Michael Federico for abuse of process. I have a responsibility filing the suit to investigate, to see if there's anything regarding that. But in absolute truth, and I state this under penalty of perjury, I have not visited Federico's home. I have not visited Nordstrom. It's in light. The reason I sent this, and it's not really a trial balloon, but I sent this notice to Mr. Dickerson and to the other parties in that note, was to see if there was any fuss made about it. And I got the ankle bracelet to prove it. I haven't been anywhere near those persons. And the court doesn't have to make any conditions. I just say I'm not going to do that until that's resolved. But the point has to be that Judge Bell, when I got back from LCC, over my objections against my will, I said that you can't really do, you're a competency court judge, and you can't really do conditions of custody. But she's nonetheless said, dropped it from, she knew it was high level before. She said, I don't think that's necessary. She put it on medium, and she didn't set any other conditions. I double checked that with my house arrest officer, Daniel Webb, and he said, Kim, there's no conditions on you whatsoever. And I said, well, I'll still let you know when I'm going to a sensitive area, like to the municipal court or whatever, because at municipal court I could run into these people, Federico or Shannon Nordstrom. And I object to Mr. Dickerson's characterization that I don't know how you put it, didn't say obsessed with Shannon Nordstrom. I've got a file, and my statute of limitations is running off on that. Both of these people, Federico and Nordstrom, filed frivolous temporary protective order requests with the Justice Court, and they were denied outright. We did have a little hearing on Shannon Nordstrom, and with Jansen on the Federico one, he did that. So they've abused process. Federico, their complaining witness, lied and...
I've seen the video, at least with respect to Federico, and he's mischaracterizing what it was. He told him, I won't grant it if you stay away from him. So that's not really an outright denial, but okay.
Perjured himself. And as a matter of fact, Dickerson and Melanie Marlin were...
I don't think that any of this is relevant, so I'm going to stop you right there. I am going to deny the state's motion to remand you. I'm going to allow you to stay on house arrest. However, I disagree that there were no special conditions. At no time was that no contact order lifted. So I just want to make sure you understand you are to have no contact with Mr. Federico and or Miss Shannon Nordstrom. Do you understand that?
Yeah, there's Federico. No first R in there. It's not Federico, it's Federico.
Okay, thank you very much. Thank you for correcting me, Federico. Okay, and so Mr. Dickerson, you can prepare the order on that. And then
So,
now there's a...
It's just to stay away from Federico and Nordstrom, right?
That is correct.
Okay.
That is correct. I do not believe that the no contact order was ever lifted. So, Mr. Dickerson, I think the next motion, let's see. The state's motion regarding his self-representation.
That's correct, Your Honor. As you'll recall, this motion was originally filed back in November of 2020. And at that point in time, it was heard, the court in December 17th of 2020 essentially held the motion in abeyance and indicated that you weren't going to grant it at that time. You were going to wait and assess how the defendant behaved going forward in this case. The state has since that time filed 3 supplements to that motion, detailing every time the conduct that the defendant has shown throughout the course of this particular case and outside of this case as well. That includes what we'd previously been discussing of the letter that he sent to the state indicating that he's going to go conduct this covert surveillance upon the victim and municipal court judge Nordstrom. In addition to that, after that January 2021 letter, we have a series of motions to disqualify that have been filed. That begins March 8th, 2021. That is what I've called in my moving papers the 3rd motion to disqualify, or the 5th motion to disqualify. April 14th, 2021, the 6th motion to disqualify. April 22nd, 2021, the 7th motion to disqualify. May 6th, 2021, the 8th motion to disqualify. May 18th, 2021 email to your court staff that was extremely disparaging. August 10th, 2021, Judge Wilson issued his order denying what he termed the 3rd motion to disqualify against you, Your Honor. He also indicated within his order that all of these motions that the defendant had been filing were in fact illegitimate, and they were only filed to gain a tactical advantage. This and goes on to my analysis of the abusive process that the defendant has continued to show during this time that this state's motion to revoke his right to self-representation has been held in abeyance. And so we filed this 3rd supplement to the motion to revoke his right to self-representation. We filed that on August 13th, 2020. In there, you see that I've also indicated under Indiana v. Edwards the extreme concerns that we see as far as the defendant's diagnosis of having a personality disorder, specifically a personality disorder that includes obsessive, schizotypal, and prominent narcissistic traits. Looking to the Mayo Clinic's definition of what that entails, we all get an idea of exactly what is going on here and what the problem is. You see that a personality disorder is an rigid and unhealthy pattern of thinking. And then from there, getting into the typology of his personality disorder, we see exactly why he continues down this path of the abusive process and refusing to acknowledge orders of the court, specifically the order of Judge Wilson, which has already indicated that his filings were illegitimate, because his response there too is then in the next days, August 18th, 2021, he then files his 9th and 10th motions to disqualify, including a motion to disqualify all of the district court judges in the 8th Judicial District, which was specifically referenced by Judge Wilson in his order as being one of the bases for him determining that these were illegitimate motions that he was filing. And then
this is just unbelievable for me to see. Again, they say you're supposed to be held to the same standard, but you never are, because he's representing himself. I happen to do civil stuff, but if you filed a motion and it was denied and you brought the same motion, you might get sanctioned that time. Probably you would get your second motion stricken with the judge telling you, don't do this again. Don't do this again. But if you brought it a third time, for sure, in the civil context, you'd get sanctions. They'd say, all right, well, now you owe the court and the other side money for wasting our time for doing this. And it could go from there, from barring evidence to all sorts of other sanctions that are available to them. Since we're in a criminal context, I think the only thing really is to hold him in contempt for that, or to revoke his right to self-representation, and that's where we're headed.
To go further, a few days after that, August 23rd, 2021, as of yesterday, he's now filed his 11th motion to disqualify. This is a continuing abusive process that the defendant is going to continue down. We are in a position right now where it has become clear. It's become clear under Ferretta that the plain terms of the U.S. Supreme Court's seminal decision on self-representation provides that this does not provide a right to abuse the dignity of the courtroom. It does not provide a right to avoid compliance with the relevant rules and procedural and substantive law. And it does not provide a right to engage in serious obstructionist misconduct, which is exactly what the defendant is doing. And case in point, when we started off this hearing today, the defendant, after the court having issued minute orders denying his motions to disqualify, begins this proceeding today by saying, Your Honor, you do not have jurisdiction to hear this case and not proceed today, because it
this might be a little dry for a lot of you, but I find it fascinating. I think the prosecutor is really doing a fantastic job. He's obviously fed up with this, but he isn't just saying, oh, he shouldn't be doing it, which is obvious, but he's really laying it out very nicely and did his homework. It's clear to me that he's on top of these issues. He looked it up. He's citing Ferretta. He's citing this Indiana versus somebody case. It's clear what it is, but he's actually asserting authority for all of it as well. He has had enough.
It evidences exactly what he has been doing. These are his obstructionist misconduct to delay this case and file these motions only for a tactical advantage to achieve that delay. Based upon that, I think he's left this court with no other option but to revoke his right to self-representation, because he continues to abuse the process, and it's clear that he's going to continue from this point forward.
Are you done, Mr. Dickerson?
I am, Your Honor.
Okay, Mr. Blandino?
Okay, well, he's lying through his teeth again.
Everything that guy just said is bullshit.
Really unfortunate that he violates his own code.
Mr. Blandino, I am not going to permit you to call the attorneys or anyone a liar. I just want to hear what you want to say in opposition. Do not make disparaging remarks about the district attorney or anyone else involved. It's not appropriate.
Well, would you prefer the term of candor? Is that appropriate?
No, I don't want you to say anything to the district attorney. I want you to oppose the motion.
In fact, Judge Wilson did not say I did it. He said he was concerned.
Well, there you have it. You had to hang in for a long time. The prosecutor did a really nice job of laying out the case, but I just love that moment. That video is longer, but I wanted to cut it off there because it's too long for my purposes, I think. But the prosecutor lays out this fantastic case, and then Kim says, "Well, he's a liar." Of course, that's what you're gonna have. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.